Hello, my name is Emily Hendrickson, and this is my discussion for week 3. So for this, we are discussing the framework of the law. So first we have constitutions and their role in the legal system. Constitutions, both state and federal, serve as primary sources of law that lay the structural foundation for their respective governing and administrative bodies, courts, citizen rights, and many other concepts relative to everyday life within the jurisdiction. Constitutions influence the actions of courts, legislatures, and government agencies by offering a framework of how each system should operate. For example, the U.S. Constitution includes a due process clause, meaning that the government is required to conduct fair legal procedures before an individual's freedoms or rights can be taken away. Thus, if due process is violated in any way, individuals can argue that they were not given fair opportunity to defend themselves. Additionally, the Fourth Amendment protects citizens from unlawful search and seizure and ensures citizens' rights of privacy. This amendment safeguards citizens from the government's abuse of authority. So what is the difference between constitutions and statutes? To preface, constitutions are not considered statutes because they are not passed by legislation with the intent to prohibit specific acts or behaviors. Constitutions rather define the structure, powers, and limits of government, whereas statutes address specific issues, policies, and regulations not fully covered in the constitutions. However, both are legal documents of primary legal authority. Constitutions cannot be overruled or superseded. They are referred to as the law of the land, especially the U.S. Constitution. In contrast, statutes are constantly subject to change. Constitutions also provide the general framework for how governmental bodies should operate, whereas statutes cover specific issues. Examples of constitutional provisions include the First Amendment, which is the right to freedom of speech, religion, press, assembly, and petition. The Second, which is the right to bear arms, and the Eighth Amendment, which is protection against cruel and unusual punishment. Examples of landmark statutes include the Civil Rights Act of 1964, which outlawed discrimination by employers, public accommodations, and federal programs based on sex, race, color, religion, or national origin. The Fair Labor Standards Act outlawed oppressive child labor and established minimum wage. Lastly, the Patriot Act was enacted in response to 9/11 and allowed for multidisciplinary communication and higher penalties for terrorism. Next, we have administrative law and regulatory authority. Because the legal system is so vast, it is impossible for one governing body, such as Congress, to create, interpret, and enforce all laws. Foreseeing this predicament, the founding fathers of our nation included a clause in the Constitution that allowed Congress to make all laws, quote, necessary and proper, unquote, for executing its enumerated powers. This clause gives Congress the authority to pass enabling acts, which grant agencies authority to carry out laws on Congress's behalf. For example, the Clean Water Act established the Environmental Protection Agency. The EPA then created more laws extending the definitions of what constituted U.S. water, and were then able to enforce legal penalties on individuals or businesses who violated the regulations. However, agencies can only make rules and regulations within the scope of their creation. Thus, the EPA cannot make legal decisions targeting terrorism. That would be the job for the Department of Homeland Security. And then lastly, we have court rules and their legal influence. Court rules ensure fairness and due process by providing standardized and predictable frameworks for legal proceedings, impartial hearings, the right to counsel, the right to present evidence and explanations, and placing the burden of proof on the prosecution. The aforementioned court rules are essential for a fair and impartial trial. Procedural fairness is the objective of the American justice system. For example, evidence submitted after a court deadline could result in exclusion of it from the trial, even if the evidence cemented a defendant's alibi. If their defense attorney did not submit it in time, then the court may decide that the evidence is inadmissible. This principle is the court's way of ensuring each party has the same amount of time to prepare for trial. And thank you.